Mr. Bogus, going back to section 16, the wild animals definition change, I don't have section 97A in front of me, but I'm curious about what implications that may have and what prompted the desire to change that.
I'll ask Major Smith to expand on that.
Major Smith.
Mr. Chair, Representative Drazkowski, this change comes to us through a decision in a court case where an individual found an animal or claimed to have found an animal on his property and said that since it's not a wild animal because it's not living, reduced it to his possession, and it was a protected wild animal. And we had operated under a lot of the game and fish, the majority of the game and fish laws talk about wild animals, possession of wild animals, and you can only possess a wild animal that's protected through a license. And we see this this change to clarify whether a wild animal is dead or alive to close what we see as potentially a major loophole. And I can give you an example. If the definition stays as is, meaning living creatures, people can start finding a lot of dead deer on their property and claiming that, well, they're not wild animals because they're not living, so I don't need to have any possession permit from the DNR. I don't need a license to have that animal anymore because it's dead and it's not by definition a wild animal. So we want to make sure that the wild animal, and we've operated in game and fish law for several decades under the definition of wild animal, under the understanding that wild animal included dead. And we're just trying to clarify that when a person finds a dead animal on their property that's a protected dead animal, that they need to have some type of possession permit in order to possess that animal, or they have to have a license in order to possess that animal.